Now let's take a look at the verdict delivered by Justice Eric Leach.
It is inconceivable that a rational person could have believed that he was entitled to fire at this person with a heavy caliber firearm without even taking that most elementary precaution of firing a warning shot, which the accused said he elected not to fire as he thought the ricochet might harm him. This constituted prima facie proof that the accused did not entertain an honest and genuine belief that he was acting lawfully, which was in no way disturbed by his vacillating and untruthful evidence in regard to his state of mind when he fired his weapon. In order to disturb the natural inference that a person intends the probable consequences of his actions, the accused was required to establish at least a factual foundation for his alleged genuine belief of an imminent attack upon him. This the accused did not do. Consequently, although frightened, the accused armed himself to shoot if there was someone in the bathroom. And when there was, he did. In doing so, he must have foreseen, and therefore did foresee, that the person he was firing at behind the door might be fatally injured. Yet he fired without having a rational or genuine fear that his life was in danger. The defence of putative private or self-defence cannot be sustained, and there is no bar to a finding that he acted with dolus eventualis in courting the death of the deceased. In the result, on count 1 in the indictment, the accused ought to have been found guilty of murder on the basis that he had fired the fatal shots with criminal intent in the form of dolus eventualis. As a result of the errors of law referred to, and on a proper appraisal of the facts, he ought to have been convicted not of culpable homicide on that count, but of murder. In the interest of justice, the conviction and the sentence imposed in respect thereof must be set aside and the conviction substituted with a conviction of the correct offence. Of course, the accused has now served a portion of the sentence imposed upon him in respect of the lesser offence of culpable homicide. But the issue of what would be an appropriate sentence was not debated before this court, quite properly, particularly in the light of the Constitutional Court's judgments in Nobelisa and Bogarts, as the matter must be sent back to the trial court for sentence to be imposed afresh. In doing so, obviously, whatever punishment has already been served by the accused in respect of the incorrect conviction of culpable homicide will be taken into account.